Our guest speaker, Mr. Devesh Pathak, proprietor of Devesh Pathak and Associates, Senior Vice President FGI, Vice President FGI, Honorary Treasurer, esteemed participants, ladies and gentlemen. On behalf of Federation of Gujarat Industries and all of us, I am extremely happy to extend a warm welcome to our guest speaker, Mr. Pathak, who will be conducting today's webinar. I also welcome all the participants today. The objectives of this webinar: companies are managed by the managing directors or directors along with the team of key managerial personnel. They are also responsible for the compliance of various laws, including the Companies Act 2013. Hence, they have to design the management strategy keeping in view of the Act also. Not only that, the Act and rules also go on changing frequently, and COVID-19 has changed the dimension of compliance of law drastically. Hence, it is also imperative to fine-tune management strategy from time to time. I understand that the role of the company secretary is very vital, especially in the compliance of the Act. In this backdrop, this webinar is organized, which I am sure would be of immense benefit to the CEOs, managing directors, owners, chartered accountants, company secretaries, CFOs, administrative heads, legal heads, etc. The Companies Act 2013 is one of the most voluminous acts of India, with around 470 sections, 7 schedules, and over 50 rules. To provide some key alerts on the subject, FGI, in association with the Vadodara chapter of Institute of Company Secretary of India, has organized today's webinar. We are extremely fortunate to have with us as our guest speaker, Mr. Pathak, who is experienced professional and who has made a mark in his organization through forward thinking and effective execution. He has kindly agreed to share his enriched knowledge and expertise to provide valuable guidance on the subject. I'll give a little brief about FGI. The Federation of Gujarat Industries was founded in the year 1918 in the erstwhile Baroda state under the progressive rule of Sriman Sayajirao Gaikwad III. It is an apex industries association and a recognized chamber of commerce, having an illustrious track record of over 100 years in the service of trade and industries. Before I conclude today, we would like to thank the RBL Bank for sponsoring today's webinar. Thank you, and over to you, Mr. Pathak.
Thank you. Good morning. Am I audible? Good morning, Mr. Manohar Chawla ji, President of FGI, Mr. Himanshu Parmar, Chairman of Vadodara Chapter of ICSI, Mr. Premal Dave, Secretary General of FGI, RBL Bank, banking partner, and my dear participants. It's my immense pleasure to share my views on the theme of general care and compliances under the Companies Act 2013. As rightly said by Chawla ji, the Companies Act 2013 is one of the most voluminous acts. And with the frequent changes in the Companies Act and rules and circulars, and especially due to this COVID-19, that compliance of the Act has become much more complex. But at the same time, compliance of the act, that is the primary responsibility of director and KMPs of the companies. I would also say that due to recent provisions under the Companies Act, some of the directors were also disqualified, and therefore they were and they are handicapped to function as a director. At the same time, there is legal maxim that ignorance of law is no excuse. Hence, it is my intention to provide some highlights of much needed major alerts. It is not my intention to discuss trade ban, just to give basic alerts so that management would be able to fine tune their corporate actions, management practices, so that fair compliance of the act can be ensured. And you may use this presentation as a ready reference also. In fact, Premal Bhai is kind enough to consent that on request, he would be able to share this presentation also. Due to paucity of time and to keep your interest intact, I have thought to restrict my presentation here. I would like to share a joke that one Gujarati, maths teacher, he was assigned duty to teach Gujarati, especially poems, because Gujarati teacher was absent. So whenever any student asked any question, and when he was not able to reply, he said that poet goes into deep and you did not understand that. So it would be my pleasure to answer your questions at last if I would know. But yes, to keep your interest intact, I have tried to shorten my presentation. I have tried to cover around some 15 areas which I feel of vital importance for complying with the laws. I have identified few areas where priority care is required. First of them is annual filing. As such, every company is required to hold AGM. And my suggestion is that preferably you should hold AGM after 30th June, but before 30th September every year. Moreover, please file to ensure that financial statement, that is AOC 4, and annual return, that is MGT 7. So both documents are filed within time. Say AOC 4 within 30 days from the date of AGM and annual return within 60 days from the date of AGM. As such, MCA has granted many extensions, but mind well, so far as filing of financial statement and annual return is concerned, there is no extension for filing document. They have to be filed within this deadline. So kindly ensure that. Moreover, if these documents are not filed, then it would cost rupees 100 per day. So over a period of time, it would become a much hefty amount. Gujarati માં કહીએ તો રોજ 100 રૂપિયાનું મીટર ચડે છે. Only that. If this AOC 4 or MGT 7, either of them is not filed consecutively for 3 years, in that case, directors of those companies would be disqualified. And in that case, they would not be able to use that digital signature. So one good thing during this COVID period is that MCA has come out with the Companies Fresh Start Scheme 2020 also. There is one more care which every director has to take. Of course, company secretaries can always help. So that is DIR3 KYC. So every year, this form has to be filed in April. And if it is not filed, in that case, that DIN can be deactivated also. Even for company also, there is a KYC. Of course, thank God, it is one time, once in a lifetime. So that form also has to be filed if not filed, and especially scheme CFSS 2020 is in offing, so one can file this also without any fees. So I would also like to share a few highlights of Companies Fresh Start Scheme 2020. Basically, this scheme was introduced with effect from 1st April. And its initial validity was up to 30th September, but they have extended it up to 31st December 2020. And best part of this scheme is no additional fees is to be paid at all, because some previous schemes also did came, but in that scheme, companies were required to file, pay some additional fees, maybe at concessional rate. But in this scheme, there is no additional fee at all. One more good feature of this scheme is that for non-filing, MCA would not initiate any action. And if they have already initiated action for non-filing, in that case, they would not pursue that. So my appeal to you that please avail this scheme. It is effective up to 31st December 2020. Now, one thing, the charges related forms and forms for increase in authorized capital, for that this scheme is not available. One more form which company should file is ADT1, that is relating to appointment of auditor within 15 days from the date of appointment. One more priority care is creation and modification of charge. So as such, company is required to file form whenever charge is created or modified within 30 days. ROC has power that they can accept forms with additional fee up to 120 days from the date of creation or modification. But terrifying thing is that after 120 days, form cannot be filed at all. No, MC, neither RD nor ROC has any power to condone delay thereafter. So one has to be very vigilant for this. Of course, MCA has also introduced one scheme for relaxation in filing belated forms for charge creation modification, but that is designed only keeping in view COVID-19, and practically, period between 1st March 2020 to 31st December 2020 is ignored for the purpose of compliance. Now, there are other few compliances also. I would like to just give highlights of that every director must have digital signature. And for filing any form of the company, that digital signature can be used. If any director wants to resign, then also he can use his digital signature, and on his own, he can file DIR 11. Another prerequisite is DIN. Before appointment of any director, DIN is necessary. DIN has to be obtained. In lighter way, I say that DIN is comparable with driving license. In a way that it is attached to individual and not to the company. Likewise, DIN is also renewable, or rather it has to be renewed every year by filing DIR3 KYC. And one cannot have multiple DIN. If it is so, then it has to be surrendered. There are also some parameters relating to maximum number of directors, minimum number of directors, maximum number of members, minimum number of members. In case of public company, there is no limit, there is no cap for number of members. There can be any number of members. Likewise, there is a cap on number of directors one individual can hold. So that cap is 20. One cannot become director of more than 20 companies, and within that inner limit that he cannot be director of more than 10 public companies. There are also some criteria that every company should have composition of different type of directors. At least one resident director has to be there in every company. Resident director means who has stayed at least for 182 days during the financial year. Relief was given up to 30th September 2020, and they have extended it up to 31st December 2020. So during this period, if there is no resident director, it is okay, but not thereafter. Some of the companies should have woman director. Like every listed company should have woman director, and other public company like those who are having paid up share capital of rupees 100 crores or more, or turnover of rupees 300 crores or more, they must have woman director. Rest of the unlisted public company did not have woman director. And in case of private company, it is absolute that they did not have woman director. Independent directors. So for that also, in case of listed company, they must have independent director. And when there is regular non-executive chairman, in that case, composition of board of directors should be at least of 1/3 of independent directors. But if there is executive chairman or promoter chairman or regular non-executive chairman, so in that case, at least 1/2 of the board should be comprised of independent directors. In case of certain prescribed unlisted public companies, they must have at least 2 independent directors. And so far, private company generally is not required to have independent director. Now, who can appoint directors? So board of directors also has power to appoint directors. Shareholders also have power to appoint directors. So board can appoint directors. Broadly 4 categories you can say. Board can appoint additional director. So additional director holds office up to next AGM. And thereafter it is the discretion of shareholders whether to continue him as a director or not, and that to retiring or non-retiring if he has offered. Additional director word would generally convey that he is sort of say extra player in the cricket team, but it is not so. Once he is appointed as an additional director, he is as good as other directors. Alternate director, as the word itself suggests, during the absence of original director out of India, when it is expected that he would be out of India for more than 3 months, in that case, it is discretion of board not of original director who is abroad, but it is the discretion of the board to appoint alternate director. Nominee director, you know, generally it is public financial institution or bank they nominate. Sometimes some shareholders agreement may be there. So in that case, shareholders may also appoint their nominee director. Filling up casual vacancy. So whenever any vacancy is caused, say if any director resigns, or say if there is a death of any director, in that case, board has power to fill up that vacancy, known as filling up casual vacancy. Now relating to appointment and resignation of director at general meeting. So at general meeting, retiring directors, if he would offer, he can also be appointed. And if he is not already director, other person can also be appointed, rather he can offer. So if any person other than retiring director is offering his appointment, in that case, he has to pay deposit of rupees 1 lakh. Why this hefty amount of rupees 1 lakh? In Companies Act 1956, deposit amount was only rupees 500. Reason being that a company of the stature of Reliance, if anybody would file his nomination for his candidature and pay rupees 500, and if his name is published all over India, people would read his name. So definitely it was not bad bargain. That's why this deposit amount is increased to rupees 1 lakh. But yes, there are some relaxations also in a way that if he gets elected, this deposit would be refunded, or say at least he gets at least 25% of the valid vote, then also deposit is refunded. One more relaxation is that when NRC, whenever there is nomination and remuneration committee, or there is no NRC, in that case, if board would recommend appointment, in that case, this deposit would not be required. Compliance relating to resignation of director. So as such, there is primary responsibility of the company to file DIR 12 in respect of resignation of director. Now, it is also discretion to the resigning director that on his own, by using his own digital signature, he can file his form known as DIR 11. And that's how he can cease to be director. Very interesting thing that under Companies Act 1956, resigning director had no discretion, or rather no power to file. So in Companies Act 2013, this discretion was given. But initially, when Companies Act 2013 was introduced, at that time, it was compulsory for resigning director to file this form. Basic purpose was that if company would fail to file form for resignation, so in order to safeguard interest of resigning director, this facility was given. But initially it was compulsory. So that reminds me of a joke. One person would used to say that my wife is so caring. If I am sleeping also, then also she would awaken me and she would give me sleeping pill. So then of late MCA realized that when company is filing, in that case, resigning director should not be compelled to file this DIR 11, and wisdom has prevailed. So now it is not compulsory on the part of resigning director to file DIR 11, especially when company is filing that. When director is appointed, he has to give consent in the form DIR 2. He has to give DIR 8 stating that he is not disqualified. and one MBP1, which he should give to the company. At the first board meeting when he participates, at the first board meeting in every financial year, and whenever there is any change. Now, disqualification of a director, I would say that this is bit recent development under the Companies Act since last 4 years or so. And every director should know when he can be considered to be disqualified. Of course, there are many parameters. I have mentioned only few parameters. One of them, as I told you earlier, that if company has not filed financial statement or annual return for continuous period of 3 years, in that case, he would be disqualified. And consequences would be that he would be ineligible to be reappointed as a director in the same company, and he cannot be appointed as a director in another company for 5 years. Practically, he continues to be director in the company which has defaulted, but then his digital signature is deactivated. So practically, he is not able to function in that defaulting company also. So what is the remedy for disqualification? Removing disqualification. There are two broad remedies, I would say. Of course, if filing is done, that would be the best thing. If it is not so, either director may make application to the High Court, praying for direction to ROC for reactivation of DIN. However, there are diversity of views by different high courts of different states. Some of the high courts give orders for reactivation of DIN. Some of the high courts do not give orders for reactivation of DIN. So this is, discretion of the High Court. Another is that if reactivation of DIN is not feasible, in that case, 2 more directors can be added from backend. In a way, that digital signatures of existing directors are deactivated, so any form cannot be filed with ROC. So in that case, shareholders can hold their general meeting, appoint 2 directors, file physical papers with ROC for adding 2 directors from backend. These are 2 broad remedies. Vacation of director. As such, the word vacation sounds very pleasant, but in the Companies Act, the word vacation is not pleasant word, because vacation means to cease to be a director. And there also major grounds are that if he incurs disqualification, which we right now discuss, if he is absent in all board meetings held during last 12 months, with or without leave of absence, then he would automatically cease to be a director. Under Companies Act 1956, there was a leverage that if leave of absence was granted to that director, he could remain absent for infinite period. But that leverage is not available under the Companies Act 2013. Then contravention of provision of section 184 means disclosure of interest and other offenses relating to related party transactions. So in that case, he would cease to be director. Some of the companies require KMPs also, key managerial personnel. So KMP broadly include MD or CEO or whole-time director or manager, plus company secretary, plus CFO. All companies are not required to appoint KMPs. All listed companies are required to appoint KMPs, that is whole-time KMPs. As unlisted public companies having paid up capital of rupees 10 crores or more are also required to appoint KMPs. So far as private companies is concerned, all private companies are not required to appoint KMP, only with the exception that private company having paid up capital of rupees 10 crores or more, they must have company secretary. So far as appointment and remuneration of whole-time director, MD, etc., there are strict and stringent provisions in respect of public company and compliance of section 196, 197, schedule 5, etc. have to be made. But so far as private company is concerned, ceiling of remuneration do not apply at all. So private company directors should not worry. So far as board and general meetings are concerned, Secretarial Standard 1 and Secretarial Standards 2, they are mandatory to be followed. But so far as dividend and board report are concerned, also Institute of Company Secretaries of India have notified Secretarial Standards, but they are of recommendatory nature as of now. Now, I would like to share few tips relating to board meetings. That yes, 7 days notice has to be given. First board meeting should be within 30 days of incorporation. Third criteria is no gap. There should not be a gap of more than 120 days between 2 consecutive board meetings. Relaxation was given in COVID period. So relaxation was given up to 30th September 2020. Surprisingly, they have given other extensions, but they have not given extension for this criterion. So now company is required to follow this rule also. And company should hold at least 4 board meetings in every calendar year. Quorum also means minimum number of directors required to be present. There is a basic principle that interested director cannot remain present at all, especially during the business where he is interested. So he cannot remain present at all. In fact, when Companies Act 2013 was introduced, public company and private company were at par so far as many restrictions were concerned. But then they realized, and some of the restrictions they withdrew, and relaxations under Companies Act 1956 are restored by notification. One of them is that in case of a private company, interested director may participate after disclosure. He can disclose that he is interested in that business and then he can participate. Maximum limit of sitting fees is rupees 1 lakh for attending every meeting of board of directors or committee. Now that also reminds me of one joke, that one director was not participating. He was not speaking at all in the board meeting. So another director reminded him that yes, you should speak something, you should share something. Then he said, see, I am being paid sitting fees for sitting in the meeting and not for participating. Now, of late, especially during this COVID-19 period, that video conferencing is permissible. As such, video conferencing is permissible for board meeting since the inception of Companies Act. But certain aspects like accounts approval, etc., they were not allowed to be transacted through video conferencing. But now, yes, up to 31st December 2020, even accounts approval to the board report, etc., is also allowed in the board through video conferencing. And thereafter, minutes of every company that should be recorded within 30 days. But it should be recorded within 30 days and it can be signed by the chairman of the same meeting or chairman of the succeeding meeting. So far as signing is concerned, it can be at next meeting. So there may be a time lag of around 3-4 months when next board meeting is held. But so far as recording in minutes book is concerned, it has to be within 30 days. Now coming to AGM, AGM also one of the crucial aspects of compliance of every company. So in every calendar year, there are basic three parameters. One, that in every calendar year, one AGM has to be held. Another criterion is that within 6 months from the close of financial year, AGM shall be held. And now legally, every company is required to have year ending of 31st March, except few companies. So practically, every company should hold AGM by 30th September. And there should not be a gap of more than 15 months between two AGMs. Sorry. However, as a COVID-19 relaxation, ROC, Gujarat, and many other ROCs, or rather all ROCs of respective state, they have granted omnibus extension for holding AGM up to 3 months. So in that case, in ordinary circumstances, when any company is not able to comply with any of the three basic parameters, company was required to make application to ROC for granting exemption up to 3 months. But this time, company is not required to make application to ROC, omnibus extension is granted up to 3 months, not beyond that. AGM is required to be held during business hours. They have specified business hours also. Under Companies Act 1956, they had not specified time, simply mentioned during business hours. So if company like Citibank, they could interpret, because they used to advertise Citibank never sleeps. So for them, 24 hours were business hours. But now they have come with specification that it has to be between 9 a.m. to 6 p.m. One more relaxation under Companies Act 1956, AGM could not be held on public holiday, including Sundays. So now this list is much restricted in a way that AGM cannot be held only on national holiday. That is 3 national holidays, you know it very well. Ordinarily, AGM shall be held within the city, town or village where registered office of the company is situated. But in case of unlisted company, now if all members agree, it can be anywhere in India. And you know very well that this time MCA has granted permission to hold AGM through video conferencing. And that benefit is available up to 31st December 2020. But in case of small company that is having lesser than 1,000 members, they can hold through VC only if they have mail address of at least 50% of members. Otherwise, they will have to hold physical meeting also only. And in that case, they will have to follow COVID-19 advisories also. EGM also extraordinary general meeting, as its name suggests, that it can be held either on its own by the board or on requisition. NCLT also sometimes orders holding of the meeting. There are other parameters also relating to general meeting. One of the important criterion is that quorum. So under Companies Act 1956, irrespective of number of members, quorum for public company was only 5 members. Imagine that company of the stature of Reliance having thousands of members, there also for constituting valid AGM, quorum was only 5 members. But they have realized, so now quorum for holding AGM is that if it is up to 1,000 members, 5 members personally present, If it is exceeding 1,000, but up to 5,000, 15 members. And if it is exceeding 30 members, exceeding 5,000 members, at least 30 members have to be personally present. Of course, companies have another option also, that so far as other than AGM is concerned, they can go by postal ballot also for certain business. Related party dealings. So that is also one of the most important criteria in the compliance management of the company. When Companies Act 2013 was introduced, company could not give loan to any related party. There was absolute embargo. Now that embargo is for giving loan, for giving guarantee, for providing security in case of loan taken by director or any firm in which director is a partner. Rest of the persons in whom director is interested, there is a relaxation in a way that loan can be given, guarantee, security can be given on their behalf by the company if broad two conditions are fulfilled, like if company passes special resolution and if that loan is utilized only for the its principal business activities. Yes, there are exceptions in a way that so far as MD or whole-time director is concerned, if it is the common service conditions for all employees, so according to those common service conditions, loan can be extended to managing director or whole-time director, but not to non-executive director. Or alternatively, by passing special resolution, some special conditions may also be given to managing director. Then loan, this exception is that when loan is given in the ordinary course of business, then this provision need not be complied with, but interest should be at a rate not lesser than the back rate. In case of holding company, to its wholly owned subsidiary also it can give loan, can give guarantee, security, provided it is used for its principal business activities. And to subsidiary also, if it is utilized for its principal business activities. There are also certain general aspects in case of related party dealings, which are covered under section 188, which we basically call as related party transactions. So one broad exception is that when related party transaction is in the ordinary course of business and when it is on arm's length basis, means arm's length basis means when there is no difference in the terms and conditions whether it is related party or not. So in that case, broadly it can be considered as arm's length basis. As I told you earlier, interested director cannot participate during the discussion of business, especially in case of public company. Related party cannot even vote in the general meeting. Not only that, if any chairman is interested, he cannot chair during that business, transaction of that business, nor he can cast his vote. But one relief is granted in the Companies Act 2013, one circular is given, because related parties may be so many. But this embargo would not apply to all related parties. It is mentioned that those who are direct parties to the agreement, this embargo would apply to them only, not to all related parties. One more relaxation is also given if 90% or more members, they are relatives of promoters or related parties, there it would be very much difficult to have disinterested quorum. So in that case, this embargo would not apply. Transactions between holding company and its wholly owned subsidiary, that is also exempted. So far as borrowings are concerned, also there are limits, especially for public companies, that they can't borrow beyond aggregate of paid up capital plus free reserves plus security premium. But this ceiling is applicable only to public company and not to private company. And there are certain powers under section 179, so they have to be exercised only at the board meeting. And for exercising this power, if board passes resolution, MGT 14 is required to be filed. But as I told you, this restriction is not applicable to private company. Deposit is one of the most, I would say, matter of concern for all companies, I would say. Before 22nd January 2019, those companies which were not taking deposits, they could jolly well forget the deposits, provisions relating to deposits. They could forget the effort to forget companies' acceptance of deposit rules also. But after 22nd January 2019, scenario has changed. Every company, whether it is taking deposits or not, company taking deposits also should file DPT-3, and company which is not taking deposit, but they are excluded borrowings, so in that case also they should file DPT-3. So it is very much pertinent to understand as to what is deposit. Because broadly speaking, definition of deposit says that any receipt of money, of course, by way of loan, they are considered as deposit. And there are certain exclusions, 25 and odds exclusions are given in the definition of deposit. I have not reproduced all those exclusions because they are too long. But the thing is that if company is falling in any of the exclusions, in that case, it will not be considered as deposit, and company did not comply with the rules relating to deposits except filing DPT-3 every year. So most of the companies need to file DPT-3 every year, because even if company might not be taking deposit, but at least they must be borrowing from the bank, most of the companies. So that is also excluded borrowing, not considered as deposit. But then yes, DPT-3 will have to be filed. There are certain clarifications also relating to deposit. Before 1st April 2014, that is under Companies Act 1956, borrowing from shareholder, especially in case of private company, it was not considered as deposit. But approach of law framers have changed. And now under the Companies Act 2013, borrowing from shareholder is a deposit, and deposit rules will have to be complied with. But yes, they were kind enough to give relaxation or clarification in a way that there are certain companies where there are carried forward deposits before 1st April 2014 from their shareholders. So technically, borrowing from shareholder is now deposit, and deposit rules will have to be complied with, but they have given clarification that if that deposit is being carried forward before 1st April 2014 in case of private company, and they have not thereafter accepted any borrowing from that shareholder, that is considered as exempted and would not be considered as deposit. Now, basically, return of deposit, that is DPT3, always required earlier that it should be supported by auditor's certificate. Now you know that there is an offshoot that companies which are not taking deposits but falling in those excluded borrowings deposits, so they are also required to file DPT3. So whether for that purpose auditor's certificate should be obtained or not. So as such, Institute of Chartered Accountants of India sought clarification from MCA, and MCA has clarified that when any company is taking deposit and filing DPT3, it should be supported by auditor's certificate. But if it is not taking deposit and still it is required to file DPT3, it did not obtain auditor's certificate. But it is my suggestion that you should keep auditor into confidence for the purpose, so that at the time of auditing there would not be any problem. Now there are certain things, one of the common problems in especially in case of a private company, because borrowing from director is not considered as a deposit. Borrowing from shareholder is considered as a deposit. And in that case, moot question would arise as to whether a person who is a shareholder and director also. So in that case, whether it should be considered as a deposit from shareholder and accordingly to comply with the rules companies relating to deposits, or to treat it as a deposit from director and not to comply with deposit rules. So law is silent on this aspect. There is no circular also on this aspect. So if let's assume that it is a deposit from shareholder, in that case all embargo relating to deposits would apply to it. And rather, if company would require the fund, in that case, up to certain limit as prescribed under deposit rules can only be given by director. At the same time, a person who is a director but not a shareholder, means he may not have much interest in the company, but his borrowing from, or rather borrowing from that director would be considered as excluded deposit. But outsider director may not be much interested to give loan. So my suggestion that in any private company, if a person is a shareholder as well as director, my suggestion is that you obtain undertaking from the company, director, that the money which is lent to the company, that is not borrowed fund, in that, and show it in the books of accounts as a borrowing from directors. So in that case, to my view, deposit rules would not apply to it. This point we have already discussed. There are also restrictions on sale, lease, mortgage, or disposal of undertaking, especially for public company, whether it is listed or unlisted. So in that case, for example, uh, if company proposes to mortgage its property to the bankers or even hypothecate its property. So in case of a public company, they should obtain approval of shareholders by way of special resolution, and then they can do so. These provisions do not apply to private company, pure private company. There are certain embargo on investment to be made, loan to be given, security to be provided, etc. So there is a limit that aggregate of giving loan, providing security or guarantee, or loan to any person or body corporate, it should not exceed 60% of paid capital free reserves and security premium, or 100% of free reserves and security premium. Difference under the provisions under the Companies Act 1956 and 2013 is that under Companies Act 1956, this embargo was relating to body corporate only, means giving loan, giving guarantee, giving security for body corporate. In this act, it is in respect of person also. So it is not only loan to any body corporate, but to any person. So all these loans given, advance given, they should be considered for the purpose of this section. But this is not absolute limit in a way that if special resolution is passed, prior approval is taken, in that case, companies have discretion to go beyond this limit also. But prior approval is required. There are exceptions also, like that when it is in favor of wholly owned subsidiary or joint venture company. So in that case, it is an exception. One more condition, not exception, that when outstanding loan is with public financial institution, in that case, prior approval of public financial institution also would be required. But if company is doing that within the limit, in that case, approval of public financial institution would not be required. Once again, coming to registration of charge, as I told you, one has to be much vigilant in a way that after 120 days, there would not be any scope for company to file creation modification with ROC. Nobody has power. So my suggestion is that many times, sometimes bankers may not give you charge creation documents like deed of hypothecation or equitable mortgage. So my request to you that you insist on the bankers or public financial institution to give them documents expeditiously so that you can file the same within 30 days. Same thing applies to satisfaction also, that documents of satisfaction should be filed within 30 days with ROC, and you have to be more vigilant even for satisfaction. Because if you don't insist for no due certificate, no objection certificate from bankers, they are not losing anything. Because if it is not filed, in that case, index of charge would continue to show them as a lender in the ROC record. So they are not losing anything. It is the company which would lose in a way that even if they have paid off the money, but that lender would continue to be showed as a lender in the records of ROC. So my suggestion to you that once payment is made or charge is satisfied, insist to the bankers or public financial institution for giving NOC so that it can be filed. Of course, in case of satisfaction, there is some relaxation in a way that regional director has power to grant condonation of delay even beyond 300 days. Of course, that is not free because application also cost much and RD also inflicts penalty. So best way would be to avoid delay. So far as increase in authorized capital is concerned, there is a requirement that yes, approval of shareholders should be taken and SH7 should be filed with ROC. There you have to file registration fee and stamp duty as applicable. So far as increase in paid up capital is concerned, there are broad two ways. One by way of right offer and another by way of private placement. In case of right offer, company should make offer to existing shareholders on proportionate basis. So for example, paid up capital is rupees 1 crore and it wants to enhance or rather offer right by 1 crore. In that case, according to shareholding, shares should be offered. And of course, shareholder would have right to renounce that. In that case, additional shares can be allocated or rather allotted to other persons also if has applied for additional shares. And thereafter also shares are left out. In that case, board has discretion to allot them in the way they wish, but not disadvantageous to the shareholders and the company. This is in case of unlisted company. In case of listed company, there are much more compliances to be made. Another way of increasing paid up capital is by private placement. So their offer is not made to all existing shareholders and therefore law requires that it has to be approved by special resolution. Moreover, offer has to be sent to all the shareholders and that offer document should be supported by valuation report by registered valuer. So to my view, private placement is a bit difficult. Right offer is a better way to enhance the paid up capital. And yes, one more thing, one more care one has to take that you can't accept cash. It has to be by check, DD or other authorized banking channel. But one relaxation is given in case of private company is that when offer is made to the existing members, in that case, offer letter is not required to be given. And since this is private placement, so you can't advertise it, you can't appoint broker, you can't pay commission, etc., etc. There are also certain parameters relating to allotment of shares. So at least 5% should be called for at the time of application. One more thing is that when you receive application money, allotment should be made within 60 days. If not made within 16 days, you must refund within 15 days of those 60 days. Because if you don't refund, it would be considered as deposit. And there are rigorous rules relating to deposit. So you should avoid considering it as a deposit. And of course, that return of allotment, that is pass 3, should be filed within 30 days and share certificate should be given within 2 months. So far as public company is concerned, now there is embargo. Whenever they make any issue, it has to be in demat form only and they must give facility for demat to all their shareholders. But this embargo is not applicable to private company. So dealing in case of private company in physical mode is still allowed, but not in case of public company. Then one important criteria is that every company which has got significant beneficial owner, so they must disclose. Rather, MCA takes this clause much seriously in a way, because it is the concern of the government to identify, especially when any body corporate holds shares in the company. In that case, one does not know as to who is the real owner or who is the real beneficiary. So this declaration is required to be given by every company. Declaration of dividend, that is also one of the usual corporate actions of most of the companies. The board has power to declare interim dividend where approval of shareholders is not required. But when final dividend is declared, so in that case, board has power only to recommend and then shareholders approve that. One major requirement is that there has to be separate banking account for dividend, and total amount of dividend has to be deposited in that account within 5 days from the date of declaration of dividend. And dividend has to be paid within 30 days. Law also requires that if there is unclaimed unpaid dividend beyond 30 days, so in that case, that amount should be transferred to unpaid unclaimed dividend account, separate account. But one practical way is to advising banker that after 30 days, the same account should be known as unpaid unclaimed dividend account. So you need not close one account and open another account. Simply name can be renamed. And company should place this deposit, details of dividend on its website also. If dividend remains unpaid, unclaimed for 7 years, so thereafter it has to be transferred to investor, education and protection fund. Of course, transferring it to IEPF is a much
We are facing some technical issue from Mr. Pathak's side. He will be joining shortly. Meanwhile, may I request all the participants to kindly send in their questions in the chat box, or you may raise the hand. We can allow you to unmute and you can ask the questions if you would want to talk to him, or you can type in your questions in the chat box. Can you hear us, Mr. Pathak?
I can hear you.
Okay. Okay. Yeah, please continue.
Yeah, sure. Yeah, sorry for interruption. Earlier, that used to be tagline in the era of Doordarshan. And there used to be a joke also that if you have your logo as sorry for interruption, it could be freely advertised. But fine. So it's okay. I think I am audible.
Yes, loud and clear.
Fine. Uh, so one more important aspect, that is of corporate social responsibility. So there are a few parameters relating to CSR. So those those companies are required to form CSR committee. So those parameters are that those companies who are having net worth of rupees 500 crores or more, or turnover of rupees 1000 crores or more, or net profit of rupees 5 crores or more. In that case, that company is required to constitute CSR committee. And in that case, company is required to spend at least 2% of its average net profit of last 3 years. Mind well that once the company falls in this criteria, thereafter, if company is out of those criteria, then also it would continue to be governed by these provisions unless for consecutive 3 years company is out of these 3 criteria, then only it would be exempted. So compulsory spending should be at least of 2% of average net profit of last 3 years. If company fails to spend that amount, or it partially spends and partially remains unspent, in that case, as of the date, if company would mention reasons in the board report, that would be enough. Most of you know that spending should be on the activities as mentioned in Schedule 7. And if company does not directly spend, in that case, it should be through trust or society or Section 8 company. What should be the constitution of CSR committee? As such, it should have at least 3 directors, and at least one of them have to be independent director. There are some companies where company is not required to appoint independent director. So in that case, it can be obviously without independent director. In case of private company, they may have only 2 directors because law allows. So in that case, CSR committee may be comprised only of 2 members. That is also allowed. Companies Amendment Act 2020 is recently passed by both houses of parliament, and president has also signed. Therefore, technically it has become act. But only thing, notification making those provision is not yet released. Therefore, provisions relating to Companies Amendment Act 2020, they are not still effective. But then I would say that CSR provisions under amendment, they have got far-reaching implications. I would like to throw light on that. There may be some companies where they might have excess spending. Means they might have spent the money, excess money, than what is statutorily required to be spent. So earlier, those companies did not get any credit for excess spending. But when this act would become effective, then they would have, chance to get credit in next financial year, also succeeding financial year. So far as of now, we don't know how many succeeding financial years that company would get credit. We don't know because rules are not notified. Provision is also not effective. But I guess that probably that benefit may be available up to 3 years. But if amount is unspent, so now there are much more clarity relating to unspent amount in the provisions. There are two broad contingencies. Some of the companies, they may not have spent full amount, but they might have earmarked amount to certain project. So phase-wise, they would spend. So in that case, it is provided that if they have earmarked amount to any project, in that case, that company should open unspent corporate social responsibility account. They should transfer that amount in that bank account within 30 days from the end of financial year, and they may spend it within 3 financial years. Means broadly, you can say that within 3 financial years, they must spend unspent amount. And if it is not spent, it should be transferred to the fund. As of now, it is not specified as to what kind of fund this will be. But I have, I guess rather, that fund would be also of the nature of investor and education and protection fund. So if company would not spend fund, that amount would not continue to be. Am I audible? Hello? Yeah, it will be, yeah. So that you have to transfer to the fund. As I told you, I don't know what would be the nature of the fund, but it would be more likely like that only. But if company has not earmarked that amount for any project, so in that case, company will have to transfer that amount within 6 months from the close of the financial year. Means they will not have chance to keep unspent amount with them. And some punishment has also been provided in the act for that. So in nutshell, so far as CSR is concerned, once this amendment would be effective, simply giving reasoning for unspending CSR in the board report would not be sufficient. Company will have to spend that amount, otherwise it would go to the fund. This is my apprehension. So far as auditor is concerned, as you know, that auditor is now under this act is required to be appointed for 5 years. It cannot be for 1 or 2 years. It has to be for 5 years only. And so far as some certain specified companies are concerned, term of appointment of auditor in case of individual can be only for 5 years. And in case of an audit firm, tenure may be for 2 terms each of 5 years. But yes, this rotation is not applicable to all companies. Yes, appointment has to be for 5 years, that is that. But this rotation of 5 years, 10 years, that is not, that is applicable only to listed company or unlisted public company with paid up capital of rupees 10 crores or more, or private company with paid up capital of rupees 50 crores or more, or those who have public borrowing of 50 crores or more, but not to all the companies. There is a requirement for appointment of secretarial auditor also in certain companies, like every listed company, every public company having paid up capital of rupees 50 crores or more, or turnover of rupees 250 crores or more, they must appoint secretarial auditor. Earlier, private company was not required to appoint secretarial auditor at all. But now one more criteria is added. According to that, every company having outstanding loans, borrowings from banks, public financial institution of rupees 100 crores or more, they also must obtain secretarial audit report from secretarial auditor. And this appointee has to be practicing company secretary. Financial statement, of course, we discussed, that is of utmost importance. These are the guidance that financial statement has to be signed either by chairman or at least 2 directors. And if there is MD or CEO, he has to sign. Then CFO, CS also must sign. There are also some requirements. So far as belated filing, we have already discussed. Board report. Board report is also one of the important documents of annual report that also needs to be signed either by the chairperson or by at least 2 directors, and if MD is there, MD or CEO is there, he should sign. It is quite voluminous, and one of the requirements is that earlier extract of annual return was required to be appended with board report. Very recently, that requirement is relaxed. So if it would place annual return on the website, they did not append this. But if they would not place it on website, in that case, still company is required to append extract of annual return with the board report. Annual return is also one of the important documents. And that is also, as I told you, it can be mentioned that it is available on web link. Earlier, under Companies Act 1956, annual return was required to be prepared as at the date of AGM. Now, it is as at the date of close of financial year. It can be signed either by director and employee CS, or if there is no employee CS, director and practicing company. In case of certain companies, it is also required to be certified by company secretary, like every listed company or a company having paid up capital of 10 crores or more, or turnover of rupees 50 crores or more. Highlights of the Companies Amendment Act 2020. I am not going to deal it in great detail. As I told you, it is yet to be effective. But yes, there are many provisions where offenses are decriminalized in a way that earlier there was provision for imprisonment and fine. So instead, penalty is that. So that way, director would not be required to go to jail for certain offenses. Then remuneration to non-executive director would also be possible even if company would have inadequacy of profit. Then in right offer also, as of now, minimum time limit for keeping right offer is 15 days. So, I mean, MC would have power to reduce that minimum time limit also. MCA would also have power to exempt certain class of companies for declaration of significant beneficial owner. And so far as CSR is concerned, that we have already discussed. Now, I am at the fag end of my presentation. Uh, I don't claim that anything and everything under the Companies Act is included in this presentation. It is just my humble, fair attempt to give major alerts, that's so in nutshell. And these are my personal views. It is not view of the institute to which I belong or to firm to which I belong. Gandhiji said that whenever there is difference in his view or opinion, in that case, latest one should be considered as conclusive. I am not Gandhiji, but keeping in view ever-changing requirements, my latest view should be considered. So that's it. Thank you for hearing me patiently. And it is just a piece of suggestion that, to my view, company secretary can be of best help in compliance management of the company. So thanks a lot for your patience hearing. Since this is webinar, this is sort of a bit impersonal. I am not able to understand your reaction, but fine. So nice of you. Thank you.
Thank you, Mr. Pathak. That was a pretty insightful presentation. We would now open the floor for Q&A. We have a couple of questions already, which you could answer.
I would love to, whatever I know.
The first question, there are two questions from the participant, Yesha. The first question says, is the provision for registration of charges applicable when private limited company takes loan from bank? And the second one is, are the following provisions applicable to private company?
Fine. Yes, registration of charge, that is equally applicable to private limited. Moreover, ADT1, DIR3, MVP1, SS1, S2, etc., they are also equally applicable to private company, barring those exceptions which have been given. So they are equally applicable to, in nutshell, they are applicable to private limited company. Fine. We may go for next.
The second question, the second question is from Mr. Jigar Patel. As per the section 173 of Act 4, meeting in Act 4 meetings in a year. As per Pathak sir, it is calendar year, but it, to my understanding, it shall be financial year also. So if you could please clarify. And the second question is, if dividend unpaid for 7 years, do we have to transfer dividend along with shares whom dividend is
fine.
pending?
So far as first query is concerned, it is mentioned, categorically mentioned in sectoral standard that it is the calendar year which should be reckoned with and not financial year. So accordingly, it is a calendar year. And next question, I couldn't see.
The next question is...
if dividend unpaid for 7 years, do we have to transfer dividend along with shares? Yes, you have to transfer shares also to IPF. Only thing, a matter of relief is that shareholder can claim dividend and shares also from IEPF, and he has to follow that procedure. But yes, dividend and those respective shares will have to be transferred to IPF.
The next question is from Mr. Deepak Joshi. Okay. He would like to ask a question online. Fine. Yes, Mr. Deepak.
Yeah, good afternoon, Pathak ji. How are you?
Fine. Good afternoon. How are you?
I'm good. Thank you so much. Pathak ji, my question is regarding, your, you briefed about the provisions regarding, appointment of statutory auditor.
Correct.
In certain cases, class of companies, the provisions are not applicable.
Yeah.
Right. Now my question is that, you know, in case if so these provisions per se are not applicable to private companies in toto?
No, you can't say.
Okay. So regardless of, you
Applicable
know,
to private company,
yeah.
I mean, if those, I mean, specifications are attracted. So we can't say, as a thumb rule, we can't say like that.
Okay, so my question is, for example, you know, let's say in the case of a parent and a subsidiary company, so parent company does not, you know, meet the criteria which requires them to, you know, rotate the auditor. But in the event of its wholly owned subsidiary, you know, is qualifying for those conditions, then what would be the provision?
So it should be followed company-wise.
Okay, so regardless of whether holding subsidiary relationship
Yes,
is not going to
absolutely.
make any difference.
Absolutely.
Okay, okay. Thank you, Pataki. Thanks a lot.
My pleasure.
There is one more question from Yesha.
Okay, fine. Earlier, sectoral audit report was not mandatory for private limited, but now with the added criterion, it is applicable to certain private limited also. You may go through that slide also. And Premal Bhai is kind enough to say that he'll share that slide also. But yes, as a thumb rule, you can't say that it is not applicable to a private company. Please.
Any further questions, please? You may type in, or you can ask me to unmute. I can unmute and you may ask the question in person as well.
Please. Thank you. Thank you, Dharmakji. My pleasure. Thank you, Mr. Dharmesh. Thank you, Mr. Jadia.
Mr. Dharmang, you can ask the question now.
Good afternoon, sir.
Good afternoon.
Sir, as you told that that is unclaimed shares, unclaimed dividend will be transferred to IPF.
Yes.
And even a shareholder can claim the shares and as well as dividend from IPF.
You're right.
So, sir, is there any time limit for claiming such IPF and dividend?
No, there is no time limit.
Okay, sir.
You can claim at any time. Only thing, responsibility of the company is to transfer after 7 years. But shareholder can claim at any time.
Okay, sir. And if in case of a shareholder doesn't claim for indefinite time, then
then government would jolly well enjoy that. But only thing that they only simply don't enjoy because they use it for investor education purpose also, as the fund is named.
Okay, sir. Okay. Thank you, sir.
My pleasure.
There is a question from Mr. Keyur. For applicability of CSR, one needs to fulfill all the 3 criteria or one?
Rather, it is your responsibility. So if company is covered in any one of the criteria, then company is, under obligation to comply with CSR provisions. Thank you, Hemant. Am I clear for your question?
There is one more question from Nisha Mishra.
Please.
Clarity on disclosures of MGT9 in board report.
Right, right. Now there is a clarity in a way. If you see the provisions under the Companies Act, especially section 92 and section 134, the word extract does not appear at all in those provisions. But then according to rule, it is provided that either you post whole of the annual return on the website of the company and give it on the web give web link address in the board report. Or if you are not giving web link, in that case, still you are required to attach abstract of annual return with the board report.
There is one more question from Jigar Patel. Is it
Yeah, please.
compulsory to shares in DMAT form for transferring into IEPF?
In fact, yes, it is compulsory. In fact, they have opened dedicated account. So for in case of a company, when physical shares are required to be transferred, so they can share those physical shares in the demat account of the IEPF. Means they should deposit those physical shares in favor of demat IEPF account. Okay. You mean to say if loan is taken from customer, whether private company is required to file DPT3 or not? Yes. Private company is also required to file. Because only thing, you have to ensure that that deposit from customer falls in the exclusions from the definition of the word deposit. Then it would not be considered as deposit. But if it is not falling in the exclusion, then it would be considered as deposit. But there is no demarcation between private company and public company. Both private and public companies are at par so far as this compliance is concerned.
Good afternoon, sir.
Good afternoon.
Sir, actually, we are collecting deposit from our new customers. So we are not taking loan, but we collect deposits when
No,
we start.
I got your point. What you want to say, you change that, definition of deposit, and there are certain restrictions also. Say, for example, if you are taking deposit from the customer, correct? So in that case, it has to be adjusted within 365 days. So it should not be more than 365 days, right?
Okay, so sir, in our case, we adjusted when we close that the business with that customer. So it is
Yes.
more than 365 days.
You should ensure, because broadly, I would say there is no time limit if it is sort of the security deposit. If it is not of the nature of security deposit, that embargo would apply.
Okay, sir. Thank you.
Most welcome.
Next question is from Mr. Jigardan. Loan to shareholders possible. Section 185 and 186.
Yes, loan to shareholder, there is no embargo. So far as section 185 is concerned, that restricts to directors and of course their relatives. So if in case of, if there is a shareholder who happens to be director and relative also, so in that case loan cannot be given.
The next question is from Mr. Bhavik Kathrani.
Okay.
He is asking, what about if appointment auditor wants to leave before the completion of 5 years?
He should resign. I hope I have answered the question. Thank you.
Yes, sir. Thank you.
Okay, fine. So far as payment of remuneration to directors is concerned, embargo or restrictions under section 197 and schedule 7 would not apply. So they may afford to forget those limits. But yes, they should follow section 196 relating to appointment. Please. Thank you, Nisha. Thank you, Jigar.
Thanks, sir.
No restriction for loan to shareholders. Yes, if it is a loan from shareholder to the company, it will be considered as a deposit and you'll have to comply with deposit rules. My pleasure.
Any questions from the participants? You may unmute yourself now and ask the question. I guess no more further questions coming up. So
before Premal Bhai, you
yes,
would take it over, I would like to express my feelings of gratitude to FGI, Vadodara chapter of ICSI, Chawla ji, RBL Bank, and especially to you and Mr. Anand Pandey. All of you for giving nice cooperation. So nice of you for reposing confidence in me. Thank you. Thank you.
thank you. So we'll proceed towards the final agenda for the day is the vote of thanks, and then it will be followed by the national anthem. So once we finish a small token of vote of thanks, we will rise up for the national anthem. So our guest speaker for today, CS Mr. Devesh Pathak from Devesh Pathak and Associates. Mr. Chawla, the President of FGI, Mr. Paresh Saraiya, the Senior Vice President, Mr. Abhishek Gangwal, the Vice President, and Mr. Bharat Shah, the Honorary Treasurer at FGI. Esteemed participants, ladies and gentlemen, I have the proud privilege to propose the vote of thanks on behalf of FGI to our esteemed guest speaker, Mr. Pathak, who addressed us really excellently, as all the comments also come in on the topic general care and compliances under the Companies Act 2013. I'm sure based on his enriched knowledge and the wonderful presentation on this subject, this entire session would have been a great knowledge sharing session. and the participants would have been benefited immensely. I must also thank Mr. Pathak to, keep this presentation so concise. The presentation was for about 107 slides, and it has been, compressed in such a format that we had to finish it in 2 hours. And commendable job on his front. Thank you very much. We would rise for the national anthem. Thank you. Thank you very much, everyone, for joining the session. We would now conclude for the day. Thank you.
Thank you all. Thank you very much, Pathak ji. Thank you very much.
Thank you, Chalda ji, for reposing confidence in me. Thank you.
Yes, thank you so much.
My pleasure.